Good afternoon, everyone, and welcome to our latest Foundations webinar. Today, we're going to be looking at payment and insolvency in the construction industry. My name is Gary Rushworth, and I'm a Principal Associate in the Construction and Engineering team at Knowles & Reeve. And I'm joined today by two of my colleagues, Patrick Wisheu and Neil Smyth. Patrick's a Senior Associate in our Construction and Engineering Disputes team, and he regularly deals with payment disputes under construction contracts. And Patrick's going to be taking you through the typical payment terms in construction contracts and how the payment process works. Neil is a partner in our insolvency and restructuring practice, and he advises businesses and insolvency practitioners when companies are in financial distress. And Neil's going to be looking at a liquidator's right to adjudicate and also at termination on insolvency in light of the Corporate Insolvency and Governance Act 2020, which is also known as CIGA. And in between Patrick's and Neil's slots, I'm going to be covering some top tips and some common pitfalls when it comes to payment under construction contracts. Before we kick things off, just to confirm that the slides will be circulated to all attendees afterwards, so there's no need to furiously scribble down notes as we go along. And a recording of the webinar will also be available if you want to pass it on to any colleagues, or if you just think it's so good that you'd like to watch it again. We would welcome your questions, so if there is anything you'd like to ask, then please use the Q&A box within Zoom, and we'll look to address your questions at the end. Our contact details are also on the slides and also on the Knowles & Reeve website, so if any other questions come to mind after we're done, then please do get in touch. But without any further ado, I'm going to pass you over to Patrick, as I say, so he can take you through the payment process in construction contracts. Over to you, Patrick.
Great, thanks, Gary. So as Gary said, I'm going to be focusing on and walking you through the payment provisions and the mechanism for payment under construction contracts. So I find when I sit down and look at a construction contract, the payment provisions just kind of jump out all over the place. So I'm going to try and present this in hopefully a bit more logical of an order by starting with 1, what can be paid, 2, when it gets paid, and 3, what you need to do to get paid or to pay the correct amount. So as all modern construction contracts in the UK should derive their payment provisions from the Scheme for Construction Contracts and the Construction Act 1996 as amended, I'm just going to focus on one form of contract, one of the ones that our transactional lawyers have been seeing quite a lot of, and that's the JCT Design and Build 2016. I'm going to be talking about it just in its unamended form because the schedule amendments will be so make it just also different that if I try to talk about any amendments, we'll be here all day. So, but don't worry, I'm going to give you the clause references as I work through this, so you can check any schedule amends to contracts you're working on to see what the differences may be. Just remember that there are some parts of the scheme that can't be varied, and if you vary them contrary to the scheme, then those bits of the scheme will get implied in. So if you're unsure on anything on that, just get in touch with us and we'll be happy to talk about it. I'm going to walk through this both on an interim payment basis and on a final payment basis. The frameworks for them are both quite similar, but they are slightly different. So starting with what can be paid, in short, it's the contract sum. That's the amount agreed by the parties and stated in Article 2 of the contract. This can't be adjusted for any reason. It can only be adjusted for the reasons given in the contract. And so for reasons that Neil will come on to later on, it's important to note that there's no general contractual right of set-off for other amounts. The amounts that can be adjusted against the contract sum are set out in the contract, and these include, for example, changes, loss and expense, defects, non-compliance with instructions, and liquidated damages. When you look at how much to be paid for any given interim payment, what you need to do is you need to assess which kind of payment mechanism is being used, either alternative A or alternative B. Personally, I've mostly only ever seen alternative B, the periodic one. And what that is essentially the sums due for works done as at the due date, whereas the stages approach is the parties set out a schedule of stages and a price for each stage, and the contractor will only get paid for those stages that are completed as at the due date. And it's also important to remember that any interim payment will be less the retention, which up to PC will be the full percentage stated in the CPs, and after PC, and up to the notice of completion of making good will be half of that percentage. So turning to when you get paid or when you have to pay, starting with interim payments, the short answer is that it's 21 days after the interim valuation date. The interim valuation date is something introduced in the 2016 suite of agreements, and it's a date to be not later than 1 month after the date of possession. So if, for example, the date of possession is the 28th of February, the interim valuation date will need to be before the 28th of March. If the CPs are silent on what the interim valuation date is, then it'll by default be, in my example, the 28th of March. Going forward and looking at future interim payments, what you do is you take that calendar date, so the 28th, and you use that as the interim valuation date in all subsequent months. That is, of course, unless that interim valuation date falls on a non-business day. So in which case it goes to the nearest business day. So if the interim valuation date, the 28th, let's say, falls on a Saturday, you go to the 27th on the Friday, or if the 28th is a Sunday, you go to the Monday. So that's the short answer. That's assuming that things have kind of gone according to plan and that everybody's put all the notices in on time. The slightly longer answer is that the date for payment is the final date for payment, which is 14 days after the due date. The due date can change slightly depending on when the interim payment application is put in by the contractor and when it is received by the employer. So if the interim payment application is received by the employer on or before the interim valuation date, then it's 7 days from the interim valuation date. So it can't be sooner than 7 days, after the interim valuation date. If the interim payment application is received by the employer later than the interim valuation date, then it runs 7 days from then. And it's important to note that it's about receipt of the interim payment application by the employer. So you want to just pay attention to how you're serving that interim payment application. To illustrate what I've just run through, I just have some timelines here just to make it quite clear. So if the interim valuation date is day 2 and the interim payment application is received by the employer on day 1, then the due date will be 7 days from the interim valuation date, so day 9, and the final date for payment 14 days later on day 23. If you flip that around a little bit and the interim valuation date is still on day 2, but the interim payment application is received on day 4, so let's say it's popped in the post and it takes that long to get there, then the due date is 7 days from day 4, so day 11, and the final date for payment is day 25, another 14 days later. Turning to the final payment, the short answer will seem quite familiar. It's 14 days after the due date of the final payment. So that's using the same mechanism as the interim payments, right? So it's 14 days from the due date, but it's quite a bit trickier to figure out when that due date is. That's because the due date is set to be 1 month after the last of the occurrence of 3 different events. So that's the end of the rectification period, which will be a period of months after PC that's set in the CPs, or by default 6 months, or the date stated in the notice of completion of making good, or the date of submission by the contractor of the final statement, or if the contractor doesn't put in a final statement and the employer puts in the requisite notice compelling them to, and the contractor still doesn't, the employer's final statement. So it's 1 month after the last of those is the due date. And to figure out what 1 month is, it's just the corresponding date in the following month. So if the last of those 3 things is on the 5th of March, then the due date is the 5th of April. And it's really important to pay attention to what the due date is and make sure you get that right, because the final statement or the employer's final statement becomes conclusive on that due date as the amount to be paid and a whole host of other matters as set out in clause 1.8. So moving on to kind of the paperwork side of things, on what you need to do to get paid or to pay the correct amount, there's 2 just kind of housekeeping points just to raise before we kind of delve into the specifics for interim payments and final payments. Those are 1, reckoning periods of days, and 2, notice provisions. I know Gary's going to talk about the notice provisions a little bit further later on, but for now it's suffice to say that the payment, any of these payment applications or notices need to be in writing and can be served by any effective means. So that includes email, unless the parties expressly agree not to. So that's something just to bear in mind if you're agreeing a communications protocol or anything like that with the other side. When it comes to reckoning periods of days, and trust me, this is going to sound a lot more confusing than it is. But it's essentially how you count the days. And in particular, it's how you count the days if something is to happen a certain number of days before or after an event. If that's the case, and you have to count so many days before or after an event, you don't count the day that the event happened on. That sounds confusing and a bit convoluted, but you get the answer you expect. So if you're looking at the due date, for example, we're talking about 7 days after the interim valuation date. You don't count the date of the interim valuation date itself. You then count 7 days from then. So if it's Tuesday, you start counting on Wednesday. So 7 days will get you to the following Tuesday. So you get the result that you'd expect. The thing to note, though, is that when you're counting these days, you count weekends, but you do not count you don't count public holidays. And public holidays are defined in the JCT as bank holidays under the Banking and Financial Dealings Act 1971. So rather arcane reference there, but it is essentially just the bank holidays you expect. So Christmas Day, Good Friday, Easter Monday, New Year's Day, the May bank holidays, and so on. So now turning to the paperwork, having covered that kind of housekeeping stuff, there's 3 principal things that need to happen or can happen for the interim payments. These are the interim payment application, the payment notice, and a pay less notice if needed. All 3 of these essentially say what the party issuing it considers to be the amount due at the relevant date. It doesn't need to just say what they think is due. It also needs to say on what basis it's calculated. So it's not enough just for the contractor to put in a slip of paper saying, you owe me £1 million. They need to show how that's calculated. And the same is true for the payment notice from the employer and the payless notice also from the employer. Taking each in turn, the interim payment application, that's the trigger. So that's what starts everything running for interim payments. As I discussed earlier, that also sets the date for the due date and the final date for payment. And in this, the contractor states the sum that the contractor considers due as of the due date, so 7 days from when it's issued. The employer then, in response, needs to issue a payment notice not later than 5 days after the due date. So that's 12 days from the interim payment application. In that, the employer needs to say what the employer considers due by reference to that alternative A or alternative B valuation mechanism that I touched on earlier. If the payment, and it also needs to set out not only what it thinks is due based off of that, but how it's calculated. If the employer doesn't give a payment notice at all, or if it's given incorrectly, then the amount to be paid on the final date for payment is the amount applied for in the interim payment application, subject to any pay less notice. So turning to the pay less notice, this is something to be given, if needed, by the employer not later than 5 days before the final date for payment. And in it, the employer states what it considers to be due, not as at the due date, but as at the date of that notice, the amount due to be paid. So that can kind of take into account anything that's happened since, or in particular, it can take into account liquidated damages that may have continued to accrue. So now turning from that framework to the final payments, just want to reiterate that the reckoning of periods of days and the notice provisions still apply to these as well. So keep those in mind. They're probably even more important in this regard because of the final payment, or the final statement, or employer's final statement becoming conclusive on the due date, like I've outlined already. These 3 notices and applications and so on all follow the same broad framework. So the final statement, or the employer's final statement, sets what the amount is that's being applied for in effect. So the final statement should be given by the contractor, and the contractor will be saying, this is what the adjusted contract sum is, this is how much I've been paid already, so you owe me the difference. In giving the final statement, or if it's the employer giving it, it needs to not only say that, but it also needs to give the details of the basis of those adjustments. So that's that point I was talking about earlier about which amounts can be adjusted against the contract sum. And again, it's really important to reiterate that the final statement or the employer's final statement become conclusive on the due date. So keep that in mind as to when that is. And if you take any issue with what is included in the final statement, or if something isn't included, to raise a dispute and give notice of that. So notwithstanding you have taking issue with it, you still need to follow through with the rest of the process. So the next step is the payment notice, which responds to the final statement or the employer's final statement. But it's slightly different because it's not always the employer who's giving it, it's the paying party that needs to give it. And it needs to be given not later than 5 days after the due date. And this needs to be given, as I've said, irrespective of the fact that you think that there might be an error in there. So you need to point out that error in this as well. Then the next step is, again, there's the opportunity to give a pay less notice. So this can be a second bite to try and address anything in the payment notice. And again, it's the amount due as at the date of that notice. So just to summarize what I've run through, I just have a couple of timelines that I've thrown together just to show you where all these different steps fall. So assuming that the interim payment application is given on the interim valuation date or before, the due date, it will be day 8 with the interim payment application being day 1. The last day for a payment notice to be given is day 13. And the last day to serve a pay less notice is 4 days later, and it's 5 days before the final date for payment on day 17, with the final date for payment on day 22. For the final payments, this looks a little bit more complicated, but that's only because you have 2 months involved, and there's those 3 events which give rise to the triggering of the due date. So you have the rectification period, then that's followed in this example by the notice of completion of making good, and the final statement being issued on day 7 of month 1. So therefore, the due date is day 7 of month 2, with the final day for the final payment notice being day 12, the pay less notice being due by day 17, and the final date for payment being day 21. So just quickly before I hand over to Gary, to see if you've been paying attention and to see if I've made any sense, I have a little pop quiz for all of you. So if the interim valuation date is Wednesday, the 28th of April, 2021, and the interim payment application is received on the Tuesday before, so the 27th of April, when is the due date and when is the final date for payment? So I have a little calendar here, and we have a poll for you to give you your answers against this. So you can see interim payment application on the Tuesday and the interim valuation date on the Wednesday. Okay, so I think we've had some results come in already. So the answer is the 6th of May. So this is for the due date. It's a bit of a trick question, and that's because the early May bank holiday on the Monday. So as I set out earlier with the reckoning of days, you don't count public holidays in there. So the due date's on the 6th. The final date for payment is 14 days later on the 20th, with the payment notice due on the 11th and the pay less notice due on the 15th. So thank you for listening, and I think Gary now has some top tips and pitfalls for you.
Thank you, Patrick. A cheeky little pop quiz there. I like that, trying to catch people out. And yeah, as I say, I'm now going to look at some top tips and some common pitfalls when it comes to payment under construction contracts. And there's 5 areas that I'm going to look at. So firstly, payment schedules. Secondly, linking payment dates to invoices. Third, the form and content of notices. Fourth, a few issues surrounding pay less notices in particular, which are a really key document. And then finally, just a few points on the service of notices when it comes to actually giving them to the other party. So my first tip is in relation to payment schedules. And in my experience, it's very common for parties to prepare and refer to a payment schedule in their contract. And it sets out all of the various dates in relation to each interim payment. And as Patrick's run through has shown, it can get a bit complicated. So these can be quite helpful. And the example on screen is an extract of the version agreed in the case of Grove Developments and Balfour Beatty, which I'll come on to discuss in just a second. And as I say, these schedules can be a really useful tool and help the parties know when each of the steps in relation to a payment need to be taken. One of the common pitfalls we see, though, is where parties don't provide for what happens in the event of a delay to completion. So if the project extends beyond the dates set out in the payment schedule, Patrick, if you just move that on, thanks. So what happens here, for example, after the 7th interim payment? And that's exactly what happened in the Grove case I just referred to. And the court determined that as there wasn't anything in the contract that addressed what would happen with respect to interim payments in the event of a delay, then there was no right to any further interim payments beyond those set out in the schedule. So in the example on the screen, there wouldn't be any right to what would effectively be interim payment number 8. And in those circumstances, the contractor needs to wait until well after PC for the final payment before it gets any more cash. And that would be the situation regardless of whether it was the employer's fault or the contractor's fault that the project was in delay. So the contractor could be entirely innocent, but have to wait from a cash flow perspective until months or years later to get the rest of its cash. Now, Patrick, just next slide, please. Thanks. So one solution that was suggested by the court in Grove was to have a schedule that referred to the date in the month by when each step was to be completed, rather than having a series of specific dates for each of the anticipated interim payments. So, for example, you require payment notices to be served no later than the 20th of each month. And in those circumstances, the entitlement to interim payments should continue regardless of any delay to completion. As a firm, another thing we've done is include express wording that provides that if there is a delay to completion, then the contractor's entitlement to interim payments will continue, and the dates will be worked out in accordance with the contract terms, and they'll essentially follow on from those that are set out in any payment schedule included with the contracts. A couple of quick bonus tips in relation to payment schedules as well. First, if you're intending to include one and refer to one, make sure it's actually there in your final contract. And secondly, make sure you check the schedule and you check the dates really carefully to make sure it actually works. Patrick, if you move the slide on, please. So the eagle-eyed among you will have spotted that in the payment schedule I put up a second ago, there was an obviously deliberate error, which is highlighted in red here. Now, both of those points sound very obvious, but there have been reported cases where those types of issues have arisen. And as a result, at least one of the parties has lost out because of the way the payment terms work. So maybe their pay less notice was late. But also, even if they, even for the winning party, they've spent a load of money on legal fees arguing about it. So like I say, obvious points, but make sure you check them. My second tip relates to invoices and specifically linking the payment dates, linking payment dates to invoices. And again, very common in amended contracts to require the provision of a VAT invoice as part of the payment mechanism. And often a party's internal payment approval process will require a VAT invoice in order for them to release payment. So you can understand why people do it. And it isn't a problem to include the need for a VAT invoice in the payment process. But the key point you need to note is that you can't link the final date for payment to the provision of an invoice. And that's because the Construction Act requires that the final date for payment will be a fixed period after the due date. And part of the rationale for that is that it provides certainty as to when a pay less notice is required. And as noted in the slides, this was addressed in the recent decision of Rushworth and Kilhan. And whilst the judge's comments on the point didn't form part of the binding bit of the decision, so it's what we lawyers like to call obiter, in my view, the decision is almost certainly correct, and I think very likely, almost certainly to be followed if it actually comes up to be decided as a point in and of itself. Now, the way to include provision of an invoice within the payment process is to link it to the due date rather than to the final date for payment. And that's exactly what the NEC has done. So shortly after the decision in Rochford, the NEC published amendments to the NEC 4 suite, which provided for the due date to be the later of the receipt of an invoice or 14 days from the assessment date. And then the final date for payment follows on a specified number of days from the due date. And before that, what they'd done in some of their contracts in the NEC 4 suite was to link the final date for payment to an invoice. So they changed that to correct that. And if you've got amended contracts, then again, or you're looking to amend contracts, then again, you're going to need to check that point. My third tip in relation to payment relates to the form and content of payment notices. Over the years, there's been loads of cases in which parties have argued over whether a notice or a payment application was valid under the contract, whether it was in the correct form, whether it had the correct contents. I'm not going to go through all the case law because we'd probably be here all night, but the upshot of it all is that regardless of whether you're issuing an application for payment or a payment notice or a pay less notice, it should be clear in substance, form, and intent what the document actually is. So the other party shouldn't be in any doubt as to what the document you're providing them with is seeking to do. So if you're applying for a payment, then that should be made obvious. Similarly, if you're issuing a notice setting out that you intend to pay less than the amount applied for, then that should be made really clear. It is possible to incorporate documents by reference when you issue a notice or an application. So, for example, you can refer back to a spreadsheet previously issued to the other party. But this is where, ideally, Zoom would have a feature where I could make some big neon flashing warning signs appear, because I think it's a risky approach. If you are doing it, then you've got to make sure you're really, really clear what document it is that you're referring to. And in my view, I think it's just a much better approach to actually attach the document to the notice, or otherwise just send it at the same time so there's no doubt what you're referring to, even if it's a document you've given to the other side 10, 15, 20 times before. There's a slightly ridiculous point on the slide about ducks, but in the systems pipework case, the court made the point that in relation to pay less notices, the best approach is to refer in the notice to the relevant clause that entitles you to serve a pay less notice, and to actually call the document a pay less notice on its face. So there's no need or benefit to shying away from saying what the document actually is. As I say, in systems pipework, they applied that, or said that relates to pay less notices. I think it applies equally to payment applications and payment notices as well. I think it's good guidance to follow. The fourth area that I want to look at is pay less notices, and then a few points that crop up with those. So as Patrick said, they're required whenever a paying party wants to pay less than the amount that's been applied for or which has been certified. A slightly niche but an important point to bear in mind is that pay less notices are required in relation to any contractual payments that arise on termination under the contract. So if there's a termination event and it leads to a payment being due from one party to the other, which there almost invariably will, if the other party disputes that payment, it needs to serve a pay less notice. And bear in mind here that on termination, payments might flow from the contractor to the employer. So it might be one of those slightly rarer cases where it's actually the contractor who's serving the pay less notice rather than the employer. That also arises in relation to liquidated damages. So if there's a delay to the completion date and the employer serves the various notices they need to levy liquidated damages, then if the contractor disputes those deductions and it disputes liability for delay, the contractor may well need to serve a pay less notice against any application for certification of the liquidated damages sums. And just to point out in relation to pay less notices, it's long been established that you can't serve a pay less notice against an adjudicator's decision for a sum that's already due and payable. So you can't try and avoid the effect of an adjudicator's decision just by issuing a pay less notice. So the final area that I want to look at relates to the service of notices. So you've put it together, you've got it in the right form. How do you actually get it to the other party in accordance with the contract? And service provisions are often tucked away in the contract, and they don't always sit with the clauses that deal with entitlement to payment, or those which oblige a party to give a notice under the contract. And the key point to make, again, probably obvious, but make sure you check the contract, check it carefully and get it right. And if you need to, then take advice. If your contract is silent, then send notices to the other party's principal business address or its registered office. And I think, as Patrick touched on earlier, you can serve by email unless the contract says otherwise. It says you can't, or if it expressly requires a hard copy, then obviously you need to send a hard copy notice. I would say if you're ever in any doubt, just send by hard copy and by email, and then you've kind of covered your bases. And then I think the final tip really on all of that is for anything important, so particularly pay less notices, get proof of postage and get proof of delivery. You don't want to end up scrapping down the line because the other side says, oh no, I never received the notice, I don't know what you're talking about. So that covers some of the top tips in relation to payment. Now, before I hand over to Neil, as I mentioned at the beginning, one of the things that Neil's going to look at is termination on insolvency in the light of a new-ish piece of legislation referred to as SEGA. And just to put that into context, most forms of construction contract include a right of termination for either party if the other party goes insolvent. So, for example, clause 8.10 of the D&B provides that if the employer is insolvent, the contractor can terminate at any time by notice. But, as Neo is going to discuss, SEGA does affect some contractual rights of termination on insolvency, regardless of what your contractual terms say. The legislation also introduces a couple of new insolvency procedures, and the standard forms haven't yet been updated to refer to them, so that might also cause a few issues. But Neil is the expert on all of this, and I don't want to steal his thunder, so I'll pass you over to him and he can explain a little bit more.
Thanks very much, Gary. Good afternoon, everyone. Before I get into the topics I'm going to talk about, just a couple of quick polls to get a feel for the audience as to their knowledge around this area. So the first poll, have you had a counterparty that's gone into an insolvency process? If you want to answer easy yes or no. It's not a trick question, unlike Patrick's. Okay, so not much in it between the yeses and no's, slightly more no's, which is good news, I guess. And the second poll is, have you heard of SEGA before today? It came into force last June, so it's been around just short of a year. Yes or no? Okay, interesting. So slightly more no's than yeses there. Okay, thank you very much for that. If we go on to the next slide. So I'm predominantly going to be talking about two main things, as was Build, which is the Bresco decision and where we are in relation to adjudication by companies in the insolvency process. But as I'll explain, for me, this is actually more an issue of set-off, which Patrick has touched on in his presentation, and I will talk about from an insolvency point of view. But before I get into adjudication, I just thought it would be helpful to provide either a brief introduction or refresher, to the extent you're aware of it, as to the various UK corporate insolvency processes, just so you're aware of some of the terminology I'll use through the presentation. As I say, I'll then talk about insolvency set-off, and then finally I will talk about SEGA and the question of termination, as Gary has teed me up to do. So next slide, if we start just briefly going through the UK insolvency processes. I'm sorry, one of those seems to have fallen off the slide a little bit, but I'm going to be talking mostly about two processes, administration and liquidation. So I'll come back to those in a minute. Briefly, as Gary mentioned, the SEGA legislation has introduced two new insolvency processes. The first is called the moratorium, and this is our attempt to get as close as we can to Chapter 11 in the US, if you have heard of that. The main differential between Chapter 11 and the other insolvency processes set out on this slide is that Chapter 11 is described as debtor in possession. So unlike in the UK, where apart from the moratorium process, the insolvency process is overseen by an insolvency practitioner, usually an accountant. The moratorium is a process whereby the directors remain in charge. They have a moratorium which prevents the creditors from enforcing their rights in the short term, with a view to them achieving an exit solution to their financial difficulties. And that process has proved so popular that I think so far there have been literally 4 applications in about 11 months. So it has not taken flight for whatever reason so far, but it's something you may come across. The other insolvency process introduced is restructuring plans at the bottom, which I'll come back to. I'll deal with these in chronological order. So company voluntary arrangements, CVAs, you've probably seen these in the press, particularly around retailers looking to dump stores and compromise landlords' claims. Receivership is, coming back to liquidation in a minute, receivership is a process used by secured creditors, either administer receivership over the whole company, although that's been phased out over a number of years now, or fixed charge receiver, where if a receiver is appointed just over say a property or a fixed charge asset for the purposes of realizing that particular asset and getting money back to the bank. Restructuring plans, as I say, are a form of scheme of arrangement. They're a court-led insolvency process. Restructuring plans have been in the news recently. You might have seen in relation to Virgin Active, who have proposed a restructuring plan that has been approved by the court, similar to a company voluntary arrangement, with a view to cramming down landlord claims and dumping unpopular leases. It is a new process that has been used more, certainly the moratorium, but schemes involve at least 2 court hearings, a very long scheme proposal document, lawyers and barristers. So it tends to be quite an expensive process, generally used by large organisations rather than smaller organisations. So that's a quick whiz through some of the processes. The processes that you're most likely to see, I would suggest, are going to be either administration or liquidation, and Bresco involve liquidation. Administration is where an administration insolvency practitioner is appointed over the company with a statutory purpose, which is usually to achieve a better return to creditors than liquidation. And that is usually achieved by selling as a going concern on the basis that the administrator has the power to trade the business. There is a hybrid of administration called pre-pax, a pre-package administration, which you may again have heard about in the press, whereby the work is effectively front-loaded. A purchaser is found before the company goes into administration, and then as soon as the administration starts, normally on the first day, the business and assets are sold to a purchaser. They've been in the press because the allegation from creditors is that they're done behind closed doors without transparency, and 60% of them on the stats are sold to management, and therefore there is a concern that the proper price was not obtained. But that is really a going concern sale that hopefully maximizes value for creditors. Liquidation, on the other hand, is a terminal process. So there's no ability to trade, there's no ability to employ. And there you are looking at a situation where basically the assets are sold off on a breakup basis for a lower value. And unfortunately, liquidation is fairly prevalent in the construction industry. Hopefully you have not come across it, but I did actually speak to a client yesterday in the industry where they were a subcontractor for a contractor who has gone into liquidation and have been left high and dry. And unfortunately, that is the reality often in liquidation and administration, because the return to unsecured creditors is often very low, if anything at all, which does raise the spectre of set-off, which I will come back to in a minute. So that's a very quick run through the various insolvency processes. So just recapping on Bresco to the extent that you're not aware of the decision. Both parties party to a construction contract, and there was a right to adjudicate. Both parties claimed money. Bresco went into liquidation, and the liquidator commenced adjudication proceedings against the other party, Lonsdale. Now, Lonsdale originally applied to the TCC for an injunction to stop the adjudication on the basis that, in essence, it was a futile exercise because there was set-off available, and therefore, the adjudication should never even start. Now, first instance, the adjudicator having made his decision, deciding that he had jurisdiction. The first instance decision was that the adjudicator lacked the jurisdiction due to insolvency set-off, and I'll talk a bit about that in a minute. And in effect, the claims under the construction contract were replaced with insolvency claims that were subject to insolvency set-off, and therefore a calculation of what net balance was due between the parties. The Court of Appeal reversed the first instance decision, but did not upheld the injunction, describing the adjudication as an exercise in futility due to set-off, as there could be no actual enforcement of the adjudication decision, but disagreed with first instance to say that the adjudicator did actually have jurisdiction to make the award that I think he rather than she had made. That then went to the Supreme Court. The Supreme Court found that adjudication and insolvency regime were not incompatible, and therefore you could still have an adjudication pursued by a company in an insolvency process. And it might still be appropriate, even though summary enforcement of it may not be available because of set-off. And they went further than the Court of Appeal and actually set aside the injunction. So where does that leave us post-Bresco, if we could go to the next slide? Well, in essence, adjudications pursued by insolvent companies are here to stay in principle and can continue. But the enforcement of the awards that the courts have held do require the liquidator to offer appropriate security to the respondent. I'll talk a bit more about that in a minute. And this was elucidated in the John Doyle case, where 5 principles were set out in considering whether an insolvent party who got an adjudication could actually obtain summary judgment to enforce it. And the main points are on the slide. But if you're only dealing with one side of the dispute, particularly when the other party is owed money, then it's unlikely that the adjudication award will be enforced. The liquidator needs to be aware of all of the outstanding financial matters between the party, particularly on the question of set-off. And the liquidator will need to provide adequate security for costs and enforcement to the respondent as if it was solvent. Now, the issue in litigating against the company in principle is that if it's insolvent, how is it going to pay your costs? Having said that, there is certain authority to say that those costs will be paid as an expense of the liquidation, which would come out before the liquidator's costs, and therefore you might be covered. But in relation to adjudication, if a liquidator obtains an adjudication award and seeks to enforce it, then the courts have said that they will need to provide adequate security to cover the costs of the other side. Now, as I say, where we really are after Bresco is that, you know, companies in insolvency process, whether that be administration or liquidation, can adjudicate, but the ability to enforce will be subject to various factors, and the main factor there which came out of all of these decisions is set-off. So moving to the next slide, this for me is more of a crucial issue for you in relation to defending adjudication claims brought by companies in liquidation, or generally dealing with companies in liquidation or administration. And this is around insolvency set-off. So insolvency set-off is automatic and arises as a matter of statute. In liquidation, it arises automatically. In administration, the situation is slightly different. So the set-off will arise where the administrator has delivered notice of an intention to pay a dividend to creditors. Now, normally, where there is going to be a distribution to creditors out of an insolvency process, the company will move from administration to liquidation for the purposes of repaying creditors. So the circumstances in which creditors are repaid through an administration is pretty rare. And so therefore the starting position is, if the company goes into administration, a creditor is not going to have insolvency set off. If the company goes into liquidation, it will. Now, what does that mean? Well, set off is a very important provision in the context of insolvency, because if you don't have set off, then what that means is that if you owe money to a company in liquidation or more likely administration, if you're not going to have insolvency set off, you have to pay that money to the company, which will go into the pot, will go down the various order of priorities, and may, but most probably will not, come back to the creditors. And even if it does come back to the unsecured creditors, of which you will be one in relation to the claim that you have against the company in administration, you will have to share those spoils with everyone else. Now, the average return on an administration is between 1 and 3 pence in the pound. And for those that have had a counterparty go into an insolvency process, your experience has probably been that the return is the square root, unfortunately, of bugger all. So set off is very important, because if you don't have it, you could end up paying what you owe and not getting anything back in relation to what you are owed. So it is a crucial way of trying to mitigate down your risk. And as I say, you don't have generally automatic set off on administration, and we have seen this recently on a number of matters, including those in the construction industry. And it is not where you want to be, because of the return to unsecured creditors is likely to be nothing. So the very strong advice from the insolvency side is set out at the bottom of that slide, which is that unless there is a good reason not to, then you as a creditor, in trying to protect your position generally against parties that go into insolvency process, but particularly against parties who then try and bring an adjudication claim against you, is that you should have contractual set off. Because in administration, if you don't have insolvency set off, then you have to rely on contractual set off. You could also rely on other forms of set off like equitable set off, etc. But it is easiest, as any lawyer will tell you, to have something that is written down and signed by both parties in a contract. Now, as has been pointed out by Patrick, there is no general set off in the JCT. And so if you just go with the JCT and you don't amend it, and your counterparty goes into administration, then on the face of it, you are not going to be able to set off any claims that you are owed against what you owe, and you will end up coughing up in full and not getting anything back for your claim. So Bresco is of interest, and it is a development that has made some lawyers lots of money going all the way to the Supreme Court. But for me, this issue is fundamentally around set-off, particularly around today's topic, which is payment and insolvency and how you best protect your position. So I think something very much to bear in mind. So just moving to the next slide, and SIGA, Corporate Insolvency and Governance Act 2020, which Gary mentioned earlier. This is a legislation that came in 11 months ago now. I've talked about the two insolvency processes that it introduced, but probably the most relevant provision for you to be aware of is around termination. And in an extension of previous legislation that sought to prevent essential suppliers from being able to terminate on insolvency, SIGA has extended that provision to provide, in principle, that no supplier can terminate on the basis of either a company's insolvency or the company going into an insolvency process. Now, that in rough terms is the termination clause that Gary described earlier. Now, there are some exceptions to that general principle in relation to small suppliers as defined under the legislation. If the company, most probably in insolvency process by that stage, consents to termination, or on the court application of the supplier, that the supplier is managed to convince the court that in order to continue supplying under the contract would cause hardship, and therefore the supplier should be allowed to terminate. So these are in essence quite far-reaching provisions, because if you've got under your standard JCT contract the ability to terminate on insolvency or insolvency process, if the counterparty goes into an insolvency process, that right on the face of it will be lost. However, often you may not be an essential supplier, and if you want to terminate, you may be able to get the administrator or liquidator to agree to that termination. And what we are seeing so far is that whilst it is the obligation of the supplier or the counterparty to make an application for hardship, if that supplier simply says, I'm terminating because if I had to continue to supply, it would cause me hardship, what they're saying to the administrators or liquidators is that is the situation, take it or leave it. And if you've got a problem with that, you go to court, but we don't have the money to do that. And therefore that is the situation. Now, that is not what the legislation says, but it is how this is tending to manifest itself on a practical level at this stage. So there are some solutions around how you draft these clauses. There are, those clauses should remain in place because you may want to rely on them in any event. But I think it comes back to tight credit control, keeping an eye on the financial information such that if you've got as much flexibility around your termination clauses as possible, either insolvency or other clauses might come to your aid if you want to bring your contract to an end with that particular party. Or as an alternative, if you've got to continue to provide essential supply, you might want to look at some other routes to recovery like guarantees, insurance, if those are available. But the bottom line is that don't assume just because you have a clause that entitles you to terminate on insolvency or an insolvency process that you will now post SIGA actually be able to rely on that clause. Thanks, Patrick. So I think that I'll hand back over to Gary.
Yeah, thanks very much, Neil. I think a really useful run through there of some really important points. We've got time for a few questions. We've had a few come in. First one I'll take probably for you, Neil. If a party objects to termination clauses based on insolvency, should we accept that in light of SIGA?
Well, I think the bottom line is that the clause may not work. But if you don't have the clause in the first place, then you're not even in a position to seek to terminate on that basis. So my answer to that question would be you need to keep the clause in as it is in the standard JCT contract, as you mentioned earlier, Gary. You just need to appreciate that you may not necessarily be able to rely on it. And in addition, because of the restrictions you've got, you might want to actually look at amending that termination clause to see whether it can kick in earlier, because the prevention on relying on this clause happens once your counterparty has gone into an insolvency process. Up until that point, you can still rely on the contract, on that termination clause. So you may want to look at whether you can tweak the drafting to actually bring it forward in time, in association, as I said earlier, with keeping a close eye on credit control. But better to have the clause than not, because at least you've got the argument, as long as you accept that it may not necessarily work if you are deemed to be an essential supplier. You may be, and the issue here is that you may not be able to now create a ransom position by saying, look, unless you pay me for what I'm owed, I'm not going to supply you going forward, and I'm going to terminate. That's really what the legislation is driving at. But the reality is that if you are an essential supplier, the administrator is going to be keen to have your supply going forward. It's really a question of how much you are owed up to the date of the insolvency process, which will be an unsecured claim rather than getting paid going forward by the administrator. So have it in, but be aware that you might not be able to rely on it.
Yeah, so you've got to keep it in, but check the position when if it comes to it, and hopefully. Yeah. Okay, thanks. Patrick, I've got one for you. What happens if a contractor doesn't make an interim payment application?
So under the design and build JCT, the interim payment application is the trigger. So if it's not put in, then it just keeps going. The due date is never actually set. That's only in the design and build. If you look at the rest of the suite of the JCT, there is still an obligation on the employer or the employer's agent to give the payment notice. So it just kind of lingers on and it doesn't really go away.
Okay, thanks. Yeah, quite an interesting distinction there as well, I think, as you say, between the various forms. I've got to admit, I don't think I've ever seen a situation where a contractor hasn't put in an application when it is entitled or thinks it's entitled to payment, but there we go. I think probably, given the time, the final question I think we'll pick up is when sending a notice, I assume you can send to a known new address rather than the notice address under Article 1.7 in the contract, or in the contract particulars, I suppose, in circumstances where a contract has moved during the contract. The answer is, in principle, yes. So if the address listed in the contract particulars isn't current, then you can send it to the new known principal business address, or to the registered office. So in the DNB, if you look at clause 1.7.3, that will deal with all of that. I think if in any doubt, a couple of practical tips. One would be contact the other party and say, where do you want us to serve notices? We know you've moved. Is this new address the best one to send them to? If it's an important notice, as these things normally are, send to the multiple addresses. So send it to the one in the contract, send it to the registered office, and then if there's a principal business address, send it there as well. It might cost you a bit in postage, but if you've got hundreds of thousands, millions of pounds riding on it, then it's probably worth a few quid on a few stamps, I would say. So that probably wraps it up there, because as I say, we're getting close to closing time. But if any questions have come through that I haven't quite seen, then we will try and contact those of you that have put those questions in. And as I mentioned at the beginning, our contact details are at the end of these slides and also on the website. So by all means, do get in touch if you've got any further queries that arise out of today. Normally here, I'd be plugging our next Foundations webinar, but with restrictions at the moment being eased, we're all going to take a summer break. So we're going to be back in the autumn for some more. In the meantime, you can sign up for our mailing list, which is on our website, and then you'll get details about any further events when they're announced. We've also got a blog at practicalcompletion.co.uk, which also has regular updates. Or you can follow our LinkedIn page by searching for Mills and Reeve Construction and Engineering. And again, that has our blogs and our events announced on there quite frequently. When you leave, if you haven't already, then there will be a feedback form, and we'd really like to hear how you think we've done today. And also if there's other topics that you'd like to hear more about and you'd like webinars on, as I say, we can consider that when planning our autumn series. But otherwise, I'd just like to say a quick thank you to Neil and to Patrick for their time today. And thanks to you for joining us. And then we hope to see you next time around. Thanks very much.